let me have food.
Shall we again come back to the first my lord? Because we need to
kindly tell me if you have arrangements.
There are 6 more.
So let me have.
When we first list the issues required, the particulars under 1, the facilities required.
I'm asking, let me have other issues in the area which outside this. Which are not in this.
Then you come and substantiate on it. You are asking, my lord, that we list the 7.
I am saying
then we come and substantiate because we have.
Can't give me others again. List them again. What is the name?
We list them, then we substantiate.
I am ready.
Okay, fine. Let's list them, then we substantiate it. Most of bragging, my lord. Facilities required by the accused person. We shall particularize them, my lord. Number 2, my lord. Record of proceedings. We shall particularize that. Management of pending applications. At least for our clients, we have to pay the application. And okay, we shall particularize, my lord. Not in importance pending applications. Number 4. Abridged facts. If then. 5. Matters in contention. 6. Witnesses. Witnesses and exhibits and documents. 7. Time free. Probably we add the 8th, my lord. We add the 8th. That is assessors. Those are the issues we'd like to canvass in the preliminary hearing. Unless the council for FBD and others have got. But on our side, those are the issues. Those that we have to do. And then we shall substantiate.
capture.
And we are not seeking to delay the proceedings. But rather, we are seeking to ensure that the objectives of free trial hearing are meaningful. The state disclosed substantial volumes of material. One of explaining is that
Is this specific on what we need to proceed?
one is going to be captured. Then the person will be captured.
It's specific so that I know what we are planning to do.
Well, the state disclosed substantial volumes of material, which was only received or recently available to the case.
What do you want to be considered at this
Time.
time for?
You not gotten adequate opportunity for the emphasis is 8 million. Full aware that we need to narrow out the issues.
I have finished in
Controversy.
It's specific on what we should look at. I have time.
Facilities. You say, for example, in courts and in prisons. Evidences, witness evidences, or witness witness. Pending application. Assessors. Agreed and contested facts. We don't have which to explain.
Can I hear from the Constitution if you have any source?
For the record, Thomas Gatiko, Assistant Deputy. My lord, for the prosecution, without them elaborating what these matters they have raised, okay, as forming part of the preliminary hearing, my lord, except for the assessors who we are prepared for, and like my learned friend said, Council Lukwago as the fourth issue for preliminary matters that agreed facts, if any. My lord, the prosecution has no agreed fact. And my lord, that means that for the prosecution, under section 67(2) of the TIA, there are no matters from the prosecution for the memorandum, section 67(2), in which the court would draw a memorandum of matters agreed. The prosecution has no agreed facts as such. All matter. And my lord, the other matters that have been raised from the understanding of the section 67, while they may affect the case, my lord, but are not matters which we believe are captured in the memorandum of agreed facts as envisaged under section 67. We show something.
I don't translate this time.
Take me through the issues raised one by one.
The first issue, my lord, the facilities required. My lord, in regards to issue number one, I would like to reiterate the provision of the end, which makes it mandatory for the state to provide adequate facilities to their guilty persons. So that one, the cornerstone. The right to fair hearing under Article 28. Article 3C. Every person is C. 3C. Every person is charged with a criminal offense shall be given adequate time and facilities for the preparation of his or her defense. So we are in readiness, time and facilities. So we are focusing first of all on the issue of facilities, adequate facilities. And the operative phrase is adequate facilities. So we have indicated Be read over and explained to the accused in a language that he or she understands, signed by the accused and by his or advocate and by the advocate for the prosecution, and then finally.
Let's go to one.
One, we have come up with a number of issues where we consider to be pertinent at this stage.
That is great issues in the prosecution.
No matter the areas, the thematic areas to be considered in the preliminary trial.
So from the defense side.
From the defense side. Number one, my lord, facilities required by the police department as issue number one. The issue number one, facilities needed or required by the police department and the act of registry.
What are the facilities?
My lord, we shall come to this issue because now I'm just generating the issue.
Just tell me where the facilities.
My lord, first of all, there are two categories. One, those required at Luzira where they incarcerated.
Under one.
Under one, they are twofold. There are those required at Luzira. And those ones are documented, my lord. Yes, they are documented, my lord, and the copy was given to court. But number one, my lord, so Mikins was filed on Friday, my lord. Yes, Mikins. But we can proceed to you can supply a copy to court, my lord. You can supply a copy to court, as I read out, my lord. Number one, my lord.
You said the fight of the Mikins. This is the copy?
Yeah, my lord, that's the copy. Go to the Deputy Registrar.
The one in your letter.
Yes.
I have.
But they are not on record. That's why I was reading them out.
It is in the letter that was filed for Mikins.
I'm reading this on Friday. May I proceed to read out the most
Did you give a prosecution also?
My lord,
Please.
if I did on this, I will not
You have the copy?
advise my lawyer
Give
something.
them the one you have. These conditions are in the letter taken of security.
Yes, my lord. I can read through very fast now.
I have the copy.
My lord, yeah,
I have captured
my lord,
the conditions and report as the letter.
I seek for the indictment.
I have taken note of these facilities which you requested the court as much as I am here.
My lord,
Counsel Clark, now
I'm
kindly say,
making a request, my lord.
I have them here.
Yes, my lord, but now,
Kindly proceedings, I have these conditions. You fight them on Friday.
my lord, I was making reference to section 67. the spirit of section 67 of the
So
TIA.
I am saying these facilities will require here, Luzira and some
If I may be heard.
I was saying this.
No, yes, my lord. Section 67.
You see,
My lord,
this one is
but my lord, on this record, the gadget has not captured the meaning. They need to be captured.
It has captured you that the facility is required to communicate with court and
That's why the reason I was going to the spirit of section 67. That it has to be done in open court, in open court and in the presence of the person. We are here, they need to listen to the facility. But it's very simple, you can read out the list.
I have a list, you have it, kindly proceed. This one I have it.
My lord, the reason why section 67.
I have finished.
No, but my lord makes a provision that the accused persons must be open court. They need to listen to this. They have no copy of the letter. Maybe you give us 5 minutes to cheer on the accused persons.
I am saying to find this letter.
Yes, my
This is
lord.
condition.
Yes, my lord.
I have said, first finish what you are doing.
But they have not seen it, my lord. They requested that we see them before coming here. And you directed that we do everything from here. And this is the reason we are here.
I am saying,
Since you are not, we are not in
and I really want to come
direction.
back and this one.
But my lord, I am asking now for fair trial that the accused person should be brought on board. Yes, I'm ready to proceed, my lord, but they should be on board. This is the point I am making. They are not on board as the facilities required, my lord. They should participate in the proceedings. That's the spirit of section 67. Yeah, but my lord, they need to understand that. Maybe you give us time so that we discuss it with them.
Any other issue? This one will come back.
Any other about this? The reason actually we are here. The reason we are here today is to go through these issues, to dash out these issues. The preliminary trial. No, the preliminary trial is all about that, my lord. The preliminary trial is about this. The preliminary hearing is about dash out these issues.
I have said this is an information. I am, give me chance to take this one. Kind of. We shall come back and see.
My lord, how do I proceed now?
Any other issue apart from other issues that
So when shall I pastoralize the issues required, my lord?
let us finish other issues.
No, there are other issues, my lord. But we wanted to first exhaust this issue number one.
Give me just the next book. Give me just the next book.
I was also seeking for audience regarding what my lord. Yes.
Let us finish this one. Let us get our next issue. Yes, Councilor.
The challenge and maybe before you is that the court has provided us these guidance to generate a record which is ideally authentic. This record that we are supposed to do,
The report is on report they have doctored it. On the issue of required conditions.
every time we appear here, we are told to speak into the matter.
Yes.
Because there is an official record.
The official report I have captured you as one of the
This record, my report has not captured the
I have reported that the required conditions were filed. And I have said one thing. I did later, but now we do I think they are
my report
but it's in here.
that matter
I am making very important. So you see, there is one condition. They want to ask them meeting. But let me not be there in any consideration to vote fair. If they are only these ones, you tell me that these are the ones you want. I go first.
But when will they be in this record?
I'm saying, I think the ones that now so that I know these are the conditions we want to consider this.
There are some of the ones who want to consider.
Others, I'm asking other people who shall come back.
Now,
to understand how we should proceed. Do we have other points that have to be discussed?
I don't know what questions are the first thing.
Is it the only that we are going to punish?
Well, there are others, but we want
Others
to
need to have
deal
it. If you don't have them,
I don't we want to deal with those.
I want to deal with issues in the data.
If you are, oh my Lord, I think this is a bit of an uncomfortable situation. Because my Lord,
Do you want, are you saying you want only to deal with the issues filed on Friday in this data?
my Lord, those
Or
are
there are other issues?
those are not our instructions. Our instructions are to first address you on those conditions.
This one, address me if there are other conditions which are not in this. They are not there. We know whether there are other issues to consider.
There are 6 more, because in total there were 7, my lord. And you
I mean
guided,
those which are not considered.
yes, there are 6 more. But you are guided that we first exhaust the first one.
No, let me have food.
Shall we again come back to the first, my lord? Because
So
we
need
need
to
to.
kindly tell me if you have other issues.
There are 6 more.
So let me have.
When we first list the issues required, the particulars under 1, the facilities required.
I'm asking, let me have other issues in the area which are outside this. We have other issues. Which are not in this.
My lord, I seek now, we seek to be guided now.
I'm begging that you have other
We are just seeking guidance. That we first list them, then we come and substantiate all of them.
This was
Look, I am asking,
you have others.
we are asking, my lord, that we list the 7,
I am saying
then we come and
give me-
substantiate, because we
will
have.
first give me others. List them here. First list them.
We list them, then we
Tell me,
substantiate.
I am ready.
Okay, fine. Let's list them, then we substantiate it. Most of bragging, my lord. Facilities required by the accused person. We shall particularize them, my lord. Number 2, my lord. Record of proceedings. We shall particularize that. Management of pending applications. At least for our clients, we have to pay the application. And okay, we shall particularize, my lord. Management of those pending applications. Number 4. Abridged facts. If then. 5. Matters in quotation. 6. Witnesses. documents. Seven, time free. Probably we add the 8th, my lord. We add the 8th. That is assessors. Those are the issues we would like to canvass in the preliminary hearing, unless the council for FAE and others have got anything. But on our side, those are the issues those that we have to do tomorrow. And then we shall start discussion.
In courts and in prisons. Evidences, witness evidences, or witness witness. Pending application. Assess. Agree and dismiss action. We don't have which to explain.
An idea from the Constitution if you have any source.
For the record, Thomas Gatiko, Assistant Deputy. My lord, for the prosecution, without them elaborating what is matters they have raised objection, okay, as forming part of the preliminary hearing. My Lord, except for the assessors who we are prepared for. And like my learned friend said, Council Lukwago as the fourth issue for preliminary matters that agreed facts, if any. My Lord, the prosecution has no agreed fact. And my Lord, that means that for the prosecution, under section 67(2) of the TIA, there are no matters from the prosecution for the memorandum. Section 67(2), in which the court withdraw the memorandum of matters agreed. The prosecution has no agreed facts as such. Or matter. And my Lord, the other matters that have been raised from the understanding of the section 67, while they may affect the case, my Lord, but are not matters which we believe are captured in the memorandum of agreed facts as a visit under section 67. We saw something, right?
I will translate this chapter.
Take me through the issues raised one by one.
The first issue, my Lord, the facilities required. My Lord, in regards to issue number one, I would like to reiterate the provision of the end, which makes it mandatory for the states to provide adequate facilities to their citizens.
Webale kulaba KKTV Uganda. Get informed and updated on issues around you and the globe as well. KKTV.